If a law never changed from the day it was written, if it carried the moral assumptions of Victorian England into the 21st century unchanged, whose life does it actually govern? On the 6th of September, 2018, a five-judge bench of the Supreme Court of India answered that question, unanimously, by striking down a 158-year-old colonial provision that criminalized consensual same-sex relations between adults. Section 377 of the Indian Penal Code was not written in India for Indians. It was drafted in the 1830s under the East India Company, shaped by the same Victorian moral framework that had sent men to prison in England for the same conduct. The British reformed their own law in 1967, after a government committee concluded that private consensual behavior between adults was not the law's business. India kept the provision for another 50 years after that. What the law actually said was this: whoever voluntarily has carnal intercourse against the order of nature shall be punished with imprisonment. The phrase "against the order of nature" was never defined. Courts interpreted it to mean any non-procreative sexual act. The practical effect was to criminalize a category of people defined by their identity, not just their conduct. Though the section was facially neutral, it applied to acts, not persons. Its operation was not neutral at all. It made the existence of a specific community a criminal matter. The road to 2018 ran through two earlier judgments. In 2009, the Delhi High Court had struck the provision down as unconstitutional. That ruling was overturned in 2013 by a two-judge bench of the Supreme Court, in a decision that remains constitutionally embarrassing. That bench had dismissed the affected community as a minuscule fraction of the population, as if the size of a group determines the strength of its rights. The court in 2018 was unsparing. The guarantee of fundamental rights does not depend on how many people are affected. Courts exist precisely to protect minorities from majoritarian overreach. 1 year before, 9 judges had unanimously decided that privacy is a fundamental right, and had specifically noted that sexual orientation is an essential attribute of that right. They had also said, in terms that left little doubt, that the 2013 decision was wrongly decided. What remained in 2018 was to complete the work. The 5 judges each wrote separately and read together the opinions amount to one of the most thorough constitutional articulations of individual dignity in the court's history. Under Article 14, which guarantees equal treatment, the court found Section 377 manifestly arbitrary. The classification it created between natural and unnatural acts had no intelligible basis. Non-consensual conduct was already covered by other provisions. What Section 377 was doing was targeting a class of people for who they are. Under Article 19, which protects freedom of expression, the provision imposed a chilling effect beyond prosecution. The court described the lived reality: constant fear, blackmail vulnerability, denial of shelter and employment, families taking children for psychiatric treatment to cure what medicine does not treat as a disease. Under Article 21, which protects life and personal liberty, the court found the most fundamental violation. Dignity is not a privilege granted by the state. It is an inherent attribute of being human. The autonomy to determine how one lives one's intimate life is a constitutionally protected sphere. When the state criminalizes that sphere, it does not merely restrict conduct. It strikes at the signature of the individual's existence. The order the court made was precise. Section 377, to the extent it penalizes consensual sexual activity between adults, is unconstitutional. The provision is not struck down entirely. It remains in force for non-consensual acts, for acts involving minors, and for bestiality. The prior decision upholding the provision was overruled. The court acknowledged what the judgment cannot do. It cannot undo the stigma, the family rejection, the lost careers, the psychiatric coercion built up over 158 years. What it does is remove the constitutional permission for all of that. The state can no longer point to criminal law to sanction discrimination. The court observed that the framers of the Constitution could not have intended the fundamental rights chapter to operate only in favor of the majority. The whole point of a rights-based constitution is to protect those the majority would rather not protect. A constitution that only confirms what the majority already believes does not need to be written down. A 158-year-old colonial provision, carrying Victorian moral assumptions about the order of nature, cannot survive constitutional scrutiny once the question is properly asked. It was never really about what is natural. It was about who the law was willing to recognize as fully human.